Thank you, Adrian, and thank you for the opportunity to speak at this conference. We've heard some excellent presentations and discussion points made in the last couple of days, and this presentation is about power purchase agreements, which is your main contract under which a mining company will regulate some of those key points that we've heard in the last 2 days. I want to start by talking about contract and risk strategy. So, a lot of people in the room who've done any transactions or looked at new projects before will say that's quite obvious. You need to look at strategies and you need to look at risks. But there is an inherent risk, we think, when dealing with new and exciting technologies, such as integrated hybrid energy solutions, for parties to get carried away and to innovate complex contractual strategies and processes, which may ultimately make your contract difficult to manage and implement and may result in an overly complex risk and liability regime. Ultimately, what parties to a contract want is to allocate risk in a balanced and reasonable way that can be readily interpreted and implemented. And the right strategy and approach is the key to simplicity. I will use the following case study from a recent matter that we've worked on to describe some of the key concepts that parties will have to consider when negotiating and structuring their PPA documentation. What we have is Mining Co. Mining Co. is an existing electricity supply agreement with Electricity Co. The agreement ends on 1 July 2018, which is not the real date. It wants to move or transition to a hybrid gas, battery, solar and wind energy model. It wishes to engage or appoint Contractor Co to develop, construct, commission and operate this facility with a view to ultimately supply all its mines' electricity needs. For that, it would need a development contract and a power purchase agreement with a start date of 1 July 2018. Its ultimate goal is to maximise the renewable energy use. So what does Mining Co really want its contract to do? It wants electricity. An electron is an electron regardless of the fuel source, which is quite simple. But what are its real goals? We've heard a lot about security of supply in the last few days, reliability at the lowest possible cost, customised for its particular project, maximising the renewable energy use, and it wants a balanced and reasonable risk allocation. And ultimately, it wants a contract and project that's commercially viable for all the parties to the deal. So how do you get to a balanced and reasonable risk allocation? Mining Co will need to look at a couple of key matters and risks in structuring and negotiating its risk position. They are ownership and control, location, cost of incorporating renewables, transitioning risk, pricing considerations, forecasting availability and efficiency, termination, and finally where it sits in the overall risk and liability regime. At the end of the presentation, I will conclude with a picture that sort of indicates the overall risk and liability regime and then some of the measures that you could incorporate under your contract to manage and mitigate those risks. So turning to the first key consideration, ownership and control. Mining Co has decided it wishes to outsource the ownership and management of the power facility to Contractor Co. The next important question then is, what is the level or degree of risk that it wishes to have in relation to that construction phase of the project as well as the supply phase under the power purchase agreement? For the construction phase, I would argue that it's not very different to any other construction PPA. The question is ultimately whether the facility is capable of delivering electricity. But during the supply phase, there's various factors that starts to impact that may make the contract quite complex. For renewables, Mining Co would need to consider forecasting risk. Who controls the availability of that fuel? Reliability and the availability of renewable energy and the fuel sources. It would need to consider what are the efficiency drivers under the contract to maximise the renewable energy penetration. Obviously, the availability and quality of data regarding forecasting, in particular in relation to wind and solar, would be very important. Depending on where this risk sits, whether it's with mining co or contractor co, the parties would need to consider how it would bear that risk and whether appropriate insurance products might be available. In relation to efficiency, and I'll come back to that in a little bit, they would need to consider what performance guarantees regarding gas consumption and renewable energy penetration can be incorporated into the agreement. The second point is location. Grid connection, we've heard a few presentations on that. It would need to do a cost analysis to make sure that it actually makes economic sense to have a renewable energy project or hybrid. A grid connection could provide a viable backup supply source, especially in the circumstances where Mining Co has an inflexible start date for its new agreement. And there are obviously a lot of grid challenges, which I'm not going to discuss in this presentation. Other factors include proximity to your renewable fuel source. That could have a direct impact on your construction costs and your upfront capital costs, and the renewable energy potential of the location where you are. In regards to the cost of incorporating renewables, it gets very interesting. Commercial viability is key, and we've heard that the levelized cost of energy is coming down. And according to Bloomberg's 2018 New Energy Outlook, it will continue to do so in relation to wind and solar technologies in the next 20 years. But what is Mining Co to do if the project is still not commercially viable or competitive? We've heard an excellent presentation by Arena, and parties would obviously look to sources of funding and grants to make their projects commercial. The value of other benefits and incentives, like renewable energy certificates, is relevant in this equation, but unfortunately the cost of an uncertain renewable energy policy is not assisting. The real question is who bears this risk of uncertainty, and who bears the risk of the cost of carbon if we don't know what that is or how it would work in the future. To manage this risk, parties would need to resort to commercial negotiations under their contracts. Mining Co and Contractor Co will have to sit down and piece together as much clarity as they can from what they know, what they think the future might hold, to work out how they might allocate this risk and deal with it. I would submit that a vanilla change of law clause would not be sufficient to address this. The question is much more complex than a change in costs. It could deal with obligations, exemptions to comply with certain legislative requirements. The question, what happens to existing exemptions and benefits that might be available today but not tomorrow? And whether one or both parties will have a choice whether to implement certain of those measures, whatever it might be under a new policy, what the cost of that might be, and whether one or both of them would be required to mitigate any of that exposure. What Mining Co really needs is certainty and clarity as soon as possible. Until then, it would need to try and use its power purchase agreement as a negotiation tool to bring as much clarity or comfort as it possibly can. For Mining Co, transitioning risk is a particular issue, since it's working with an inflexible start date for its new agreement. But furthermore, in a hybrid model, you are faced with the potential complexity of various completion dates for the construction of your various facilities of wind, solar, and gas. You might deal with different target dates under your contracts for various milestones and various supply commencement dates and supply periods. And this is where I would like to take you back to the complexity point I made in the beginning. Contracts can be drafted to allow for all these different scenarios and periods, but it may not be what you want. We simplified this by selecting one accountable fuel source and linking that to the inflexible start date of 1 July. There will still be risk of extensions and delays, and you would still need to manage that because you still have an inflexible start date. The key to simplification may have been incremental or staged approach. But the question is still who bears the risk of delay, because you need to meet that specific start date. You could provide for mechanisms under your contract like liquidated damages, but ultimately, as we all know, there's always caps on liquidated damages and limitations of liability. So it's very possible that that risk will eventually sit with Mining Co, and it would need to make sufficient arrangements for backup supplies and consider its insurance options. The last two elements deals with pricing and termination. Pricing under your contract, consideration to any take-or-pay provisions. You'll have flexible and variable charges as you would under any PPA. But the potential complexity that comes in with delays and different completion dates that's staged might provide some solution, but ultimately, because we had a staged or incremental solution regarding delays and start completion of one base fuel, it informed an appropriate pricing mechanism whereby you would adjust your fixed and variable charges as different parts of the facility come online and are completed. Within the pricing mix, Mining Co has to consider energy efficiency and how it will deal with that in the documentation. It can consider incentives and guarantees to maximise renewable energy penetration and minimise or set targets regarding gas consumption. The measures to really control that under the contract could be in price adjustments or in other types of remedies like liquidated damages. Ultimately, every contract will have termination provisions. In this type of contract, that is obviously the last resort because that's not what you want at all. So parties will inevitably have to negotiate very carefully step-in rights and purchase rights and procedures and mechanisms around that under the contract to give them some comfort regarding those issues. And obviously, your damages provisions as well. So what does this look like? What does your risk and liability regime look like? So reflecting back, what you have is you've got various risks there. Construction and performance is the first one. In relation to that, your management measures might be remedial action by the contractor, step-in rights for Mining Co in case of significant defaults or non-performance, damages provisions, and then insurance. From a forecasting risk perspective, it really depends where the risk ultimately sits. If it sits with Contractor Co, there could be consequences around price adjustments or liquidated damages. If it sits with Mining Co will have to consider whether there's any insurance products or financial products in the market that could help it mitigate or manage this risk. In regards to delay risk, because we're working with an inflexible start date, this is quite critical. Both parties would have certain obligations in this regard to minimise that risk. Mining Co would need to make sure it's got backup supply arrangements in place, potentially insurance if the eventual or residual delay risk sits with it. There might be provision in the contract for excusable delays, for delays outside of Contractor Co's control, or any variations or time extensions that might be necessary in relation to the construction phase, and liquidated damages. Regarding energy efficiency, guarantees and performance, there could be price adjustment mechanisms to incentivise that maximum renewable energy penetration under the contract, as well as liquidated damages. Termination and default risk. Although that's the last resort, the remedies that you would seek to include in your contract would include step-in right, purchase rights, damages, and perhaps performance guarantees and other security. And then last but not least, regulatory risk. Until we have more clarity and certainty, parties would have to commercially negotiate a position that is acceptable to both of them, and perhaps consider what insurance or financial products might be available in the market. So what are the lessons learned? Simplicity is key. Because we deal with a new technology and various pieces that we would like to consolidate and integrate, there is an inherent temptation, perhaps, to complicate your drafting and strategy under your contract. As lawyers, we can draft almost anything in an agreement, but that may not be what you want or need. And mining co's technical, commercial, and legal advisors would need to work together to actually simplify the contract and the risk profile, to make sure that the contract is as simple as possible and as easy as possible to implement. Understand that your power purchase agreement is your main risk allocation tool. And finally, that it's also a key instrument of project finance. So in conclusion, aim for simplicity as far as you can and do your risk matrix upfront. Thank you.